Hello, and welcome to our lecture on the third branch of government, that of the judiciary. And after this lecture, you only have one more to go, and you are finished. So give yourself a pat on the back, and make sure you turn in all your work too, because probably won't pass if you don't do that. All right, so the third branch of government is the judiciary, and of course you probably know at the very top of the judicial branch is the U.S. Supreme Court. And there is a picture of the current 9 justices to the Supreme Court. John Roberts, Clarence Thomas, Neil Gorsuch, Samuel Alito, Brett Kavanaugh, Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, the current 9. I remember a few years back there was a poll taken where people were asked to name 3 justices of the Supreme Court, and only 20% of Americans could name 3 or more. Meanwhile, the majority could name the 3 Stooges. So maybe that's an indication of where public knowledge is right now. All right, so the Supreme Court is created, and the judicial branch is created by Article 3 of the Constitution. According to Alexander Hamilton, the judiciary is the least dangerous branch of government. And it was also envisioned as being the weakest of the 3 branches of government. Though, like the presidency, it has become more powerful as time has gone on. All right, so why do we have a judiciary? Why do we have courts? The answer is to resolve legal disputes using the adversarial system. And this is based on the English legal tradition, which is where the adversary process comes from. And what is this adversarial system, you ask? Well, it is a system where each party presents its version of the events, and virtually all attempts to slant information short of lying under oath is acceptable. So you're not allowed to lie under oath, obviously, but if you watch court proceedings, you see that they can come pretty close. Events can be interpreted in very different ways. So this is the adversarial system. Each side gets to present the case however they want, so long as they don't outright lie under oath. All right, so we are a nation of laws, as John Adams famously said, and the law consists of 4 components. American law consists of 4 components. First being natural rights, which go back to John Locke, who famously said all humans possess 3 natural rights, those being life, liberty, and property. Rights originate from God or from nature, not from government. So in other words, the government doesn't grant rights, the government cannot take them away. Any government which doesn't respect natural rights is illegitimate. And we have these rights simply because we're human. Not only that, but more radically, we probably have a moral obligation to break a law if it is unjust. An unjust law is no law at all. I believe Lord Acton said that. I have to look it up. But the idea here is that if the law requires you to do something that is wrong or immoral, you have an obligation not to follow it. Next view is going to be the sociological view. This is the idea that laws also emerge as a gradual growth of rules and customs of society. In our culture, for instance, you're only allowed to have one spouse at a time. This is not the case everywhere. Some countries allow you to have multiple spouses. Why are you only allowed to have one? Well, probably it's just embedded in our culture going back to religion, probably. Another thing is English common law, specifically stare decisis, which means you stand by previous decisions. So what this means is that if a judge is hearing a case that involves an issue that has been litigated before, the judge will cite that case and say, nope, this has already been settled. See Smith versus Jones, 1945. So past decisions are almost always upheld. Occasionally they are overturned. But if you're suing and trying to overturn a previous Supreme Court decision, it's pretty difficult. It can be done, and it is done sometimes. But, Brown versus Board of Education overturned Plessy versus Ferguson. But you have to typically demonstrate why the court was wrong and erred in their previous judgment, which is hard to do. The default is typically that the previous ruling stands. Also, laws can come from Congress, state legislatures, or local government statutes passed by legislative bodies, either at the federal, state, or local level. Also, you probably know, we're based on the idea of trial by jury. This concept goes back to the Magna Carta when it replaced trial by ordeal. Trial by ordeal was tying someone to a brick and throwing them into the river, and if they sink, they're innocent. If they float, they're guilty. Things like that. So trial by jury is certainly a step forward from that. It involves questions of fact. In a criminal case, if you are convicted, you have the right to appeal. You cannot appeal an acquittal. Why do we have the right of appeal? Because the legal system does sometimes screw up and make mistakes. So if a ruling goes against you, you can appeal to a higher court. Of course, the higher court is looking only at the trial procedure and making sure it was correctly followed. They don't, or not supposed to at least, make a judgment on what the actual ruling was. So in other words, whether or not the higher court agrees with the ruling is not relevant. What is relevant is whether or not the lower court followed proper procedure. If they did not follow proper procedure, and the higher court feels that this may have affected the outcome of the trial, then they can overturn the lower court's decision. Of course, appeals can lead all the way to the Supreme Court, though very few cases actually make it that far. Constitution creates the judicial branch in Article 3 of the Constitution, as well as the Judicial Act of 1789, which established the court system. Article 3 briefly refers to the Supreme Court of the United States and grants Congress the authority to create lower courts at its discretion. The Constitution, though, is somewhat vague on what the actual role of the Supreme Court is. Doesn't say how many justices the Supreme Court there should be. Doesn't say explicitly that the Supreme Court has the authority to strike down acts of Congress or acts of the President. We'll get to that in a minute. A jurisdiction is the lawful authority of a court to hear a case. So there's two types of jurisdiction for the Supreme Court: appellate and original. Appellate is a case the court hears from an appeal from a lower court, and either state or federal court. And this is by far the most common type. The other type is original jurisdiction. This is where a case goes directly to the Supreme Court, no lower courts hear it at all. This is pretty rare, usually involves disputes with foreign dignitaries or disputes between states. The vast majority of cases the Supreme Court hears are heard from appeals from lower courts. All right, judicial appointments. So there's 9 Supreme Court justices who serve for life, as do federal judges. President has the authority to nominate federal judges up to and including the Supreme Court with the advice and consent of the Senate. So President nominates someone and the Senate considers them and ultimately votes on whether or not to confirm them. If 51 senators vote to confirm, then the justice goes on to the court. If fewer than 51 vote to confirm, then they fail, then they are rejected. Once confirmed to any level of the federal judiciary, district courts, circuit or courts of appeals, or the Supreme Court, they serve for during good behavior, which essentially means life, unless they are removed or unless they retire. And this is designed to protect the concept of judicial independence. Judges can't be removed because of partisan disagreements with their decisions. So you appoint a justice, they are effectively shielded from political considerations and from public opinion. The idea being that we have the legislative branch, which is accountable directly to public opinion. We have the executive branch, which is somewhat indirectly through the Electoral College. So both of them should represent majority opinion. Majority should typically get what they want. The judicial branch, though, is here to protect the rights of minorities, people who disagree with the way things are going. Can a majority become oppressive to a minority? Absolutely they can. Look at slavery. Look at the Jim Crow era. The courts are designed to try to prevent stuff like that from happening. So the courts are there to protect the rights of unpopular people or viewpoints or things like that. All right. So the greatest power of the Supreme Court is in judicial review. This was not literally expressed in the Constitution. Instead, it's established in the Marbury versus Madison case of 1803. Alright, so judicial review is the authority of the Supreme Court or courts to strike down laws passed by Congress or acts of the president or the executive branch. Basically, the court created this power for itself here, though it does have roots in English legal tradition of appeals. Now, couple things. The Marbury versus Madison case is an interesting one because it involved John Adams' midnight appointees. What this meant was Adams had lost the re-election of 1800, his re-election campaign in 1800. But of course, when you lose election, you don't leave office immediately. There's a lame duck session, which at the time lasted about 5 months, I believe. And during this time, Adams appointed as many Federalists or political allies of himself as he could to federal posts. Thomas Jefferson didn't like this. He thought that it amounted to Adams stacking the deck against him coming into office. And so when he became president in 1801, he stated he would honor all the appointees that Adams had made if the proper paperwork had been completed. If it had not been completed, he would not honor them. And one of those whose paperwork wasn't completed was a guy named Marbury, who'd been appointed Justice of the Peace in Washington, D.C. Marbury sued and argued that he was entitled to that appointment since Adams had made it. The case went to the Supreme Court, and Chief Justice Marshall ruled against Marbury in Jefferson's favor. But he did it in a way that Jefferson hated. Jefferson didn't believe that the court should have the authority to strike down acts of Congress. He also didn't want to appoint Marbury Justice of the Peace. So Marshall trolled him a little bit. He gave him what he wanted, gave Jefferson what he wanted, ruled that Marbury wasn't entitled to that appointment, but he also struck down a section of the Judiciary Act of 1789 as unconstitutional. So this was the first time that the Supreme Court had struck down an act of Congress. And this set the precedent that this was allowed. And pretty much every decision since then that strikes down an act of Congress, or every single one that strikes down an act of Congress, is doing so because of the precedent set in Marbury versus Madison, which makes Marbury v. Madison probably the most important Supreme Court decision in American history. Going on to talk about the guy Marshall. John Marshall was appointed Chief Justice of the Supreme Court by John Adams. He was not the first Chief Justice of the Supreme Court. Actually, technically, it's the Chief Justice of the United States. He was not the first. John Jay was the first. He was appointed by Washington. But Marshall was the first great one, the first important one. He probably is the most influential one on the court as a whole. He notable for a number of cases which he oversaw, the Marbury v. Madison decision, which formed the basis for judicial review, and basically the basis for the entire Supreme Court as we know it today. He oversaw the McCulloch versus Maryland case. This is a court case where he ruled that the necessary and proper clause of the Constitution granted the federal government the power to create a national bank. There's nothing specifically in the Constitution about a national bank, but Marshall ruled that the necessary and proper clause empowers the Constitution to do, empowers the federal government to do it. So it's a little bit of a looser reading of the Constitution. Most of what the Congress does today is also not specifically in the Constitution. There's nothing in there about Social Security, Medicare, Medicaid, National Park System, education, etc. But since the courts have ruled that necessary and proper clause means you can do things that aren't specifically in there. Going back to McCulloch versus Maryland, those are all allowed. So this is a significant decision. The Givens versus Ogden case, the court held that the federal government has the power to regulate interstate commerce, even if it included commerce only within one state, if that commerce impacted commerce in other states. So a transaction happening in Tennessee can affect economics, commerce in Kentucky. Therefore, the federal government has the right to step in, even if it's entirely within the borders of Tennessee. And Cohen versus Virginia, this established the authority of federal courts over state courts, which upheld the supremacy clause, which means that federal courts and ultimately the Supreme Court had the final say over what the law means. So the court, as we know it today, and the role that it fills as we know it today, was solidified during John Marshall's time as Chief Justice, which lasted 34 years. After Marshall's leaves, though, the Supreme Court takes a much more hands-off approach. For over 100 years, the Supreme Court limited national power over slavery, civil rights, and the regulation of the economy. During this time, we get some of the worst decisions in Supreme Court history. The 1850 Dred Scott versus Sanford decision, usually considered the worst Supreme Court decision in American history. In this case, the Supreme Court ruled that African Americans were not U.S. citizens. Congress did not have the authority to regulate slavery in the territories, and this is pretty much a direct quote: "No black man has any rights that a white man is bound to respect." So you can see why this is usually considered the worst Supreme Court decision ever. In 1896, Plessy versus Ferguson, the court ruled that separate but equal schools are constitutional. And it would be 58 years before that's going to be overturned in Brown versus Board of Education. The Supreme Court prevented post-Civil War attempts to regulate the economy by narrowly interpreting the Commerce Clause and using the Due Process Clause to prevent state laws from regulating the economy as well. It wasn't until the 1930s that the Supreme Court becomes a bit more activist. Several New Deal programs were struck down by the Supreme Court. In 1932, we talked about this already, Roosevelt's elected. Most Americans wanted government to take more action in the active role in the economy. We talked about the court packing plan. We talked about the presidency. Basically, Roosevelt wanted to appoint a bunch of new justices to the Supreme Court to try to skew it his way. This didn't happen, but a couple of his critics on the court did step down as a result, and he got to appoint 2 new justices, so the court did end up going in his favor after this. And the Supreme Court ended up upholding Social Security by only 1 vote. It was a 5-4 decision. So that had gone, one person had gone to the other side, history would have been a lot different. 1950s, from 53 to 69, we get the era of the court in which Earl Warren is the Chief Justice. He was appointed by Dwight Eisenhower, much to Eisenhower's later regret. Someone asked Eisenhower after he left office if he made any mistakes as president, and he responded, "Yes, I made 2, and they are sitting on the Supreme Court." The other one was William Brennan. Under Earl Warren, the Supreme Court became much more activist. One of the most significant decisions it made was the Brown versus Board of Education of Topeka, Kansas decision in 1954, which struck down segregation in public schools. It also expanded the rights of the criminally accused through the Miranda versus Arizona decision. You ever heard of this? I'm sure you have. What are your Miranda rights? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be provided for you. So, according to the Constitution, you have the Fifth Amendment right to refuse to answer any question on the grounds that you may incriminate yourself. And you also have the right to count legal counsel in a trial. These rights existed before the Miranda decision. There's nothing, though, in the Constitution that says that a suspect has to be informed that they have these rights. So, if you're a cop and you're arresting someone, are you going to help them out by telling them that they don't have to answer your questions without a lawyer present? Probably not. If the suspect doesn't know this, then you're probably not going to help them. If they know this, they can invoke them, but if they don't. The court ruled, though, that this is not, that any suspect has to be informed of their rights in the Miranda case, and if they are not, anything they say before they're informed of their rights is inadmissible in court. There's a few misconceptions about this. One is that if a cop forgets to read you your rights, then you walk. Not necessarily the case. It just means that whatever you told them before you read your rights is inadmissible in court. If they have enough evidence to convict you without a confession, then they're probably going to do it. Of course, if you tell them something, you say, oh yeah, the murder weapon is here, and they go find the murder weapon based on that, and it was something you told them before you read your rights, then that is fruit of the poison tree, which means that it would be inadmissible in court. The Miranda case is kind of interesting. Ernesto Miranda was the guy involved. He's a First Amendment hero. And by hero, most First Amendment heroes are not really heroes. Think Westboro Baptist Church, think Ernesto Miranda, who was a terrible person. He was a rapist and an abuser of women who was convicted without having been read based on confessions. He argued that he had not been informed of his rights, that he had a lawyer, and his conviction was illegitimate because of that. The case made its way to the Supreme Court. The Supreme Court ruled in his favor. So the state tried him again, which they can do since he was not acquitted. And they convicted him again. He went back to prison for several more years, eventually got out, and ended up dying in a bar fight. And the person who killed him was arrested, brought downtown. Guess what he had read to him? His Miranda rights. So, Warren Court. The Warren Court also created the right to privacy in the Griswold versus Connecticut case. What is this? There is nothing explicit in the Constitution that says you have a right to privacy. But it might be implied by the Fourth Amendment. You have the right to be secure in your person's papers and effects against unreasonable searches and seizures. Or the Ninth Amendment, which says you have more rights than are outlined here. Griswold versus Connecticut case involved birth control. Birth control had been legalized. The pill had been legalized or been approved by the FDA in 1963, I believe. And it was controversial in some states, including Connecticut, made it illegal. Griswold sued and argued that she had the right to purchase contraceptives of her own based on the right to privacy. The Supreme Court agreed with her, and this created the precedent of the right to privacy, which is going to be cited later on in Lawrence versus Texas and Roe versus Wade, which we'll talk about in a little bit. So, the Warren Court created the precedent of the right to privacy. The Warren Court also struck down prayer in public school if it is led by a teacher or authority figure in the Engel versus Vitale case. Still super controversial today. All right, 69 to 86, the Chief Justice of the Supreme Court is Warren Burger. And this court is more conservative than Earl Warren, but it would be wrong to say it's completely conservative. It did tend to side with police over defendants more often than the Warren Court did, but it also oversaw a number of cases which might be considered more liberal. In 73, for example, the Roe versus Wade decision, which effectively legalized abortion nationwide in the first trimester of a pregnancy. It drew from the right to privacy precedent, which was established in Griswold versus Connecticut. It also continued to oppose segregation and continued to support the release of the Pentagon Papers. It also struck down the death penalty in 72, but reinstated it in 76. So it's kind of a mixture of liberalism and conservatism. It's also notable because in 1981, Reagan appointed Sandra Day O'Connor to the Supreme Court, and she is the first female justice to serve on the court. From 86 until 2005, Chief Justice of the Court was William Rehnquist, who continued the trend more towards conservatism. Continued to side with police over defendants, although not entirely conservative. Texas versus Johnson case in 89, it ruled that burning of the flag is protected as free expression under the First Amendment. Did rule that schools can censor plays in newspapers. Also ruled that police can, if you take your trash out to the curb to be picked up by the garbage truck, then the police can actually pick it up and go through it without a warrant because you've put it on public right of way. So the Rehnquist court is kind of divided. Current Supreme Court Chief Justice John Roberts, also more conservative than liberal, but a little unpredictable as well. We saw the court ruled in favor of gay marriage, for instance, right? We also saw that the court upheld the Affordable Care Act. So generally more conservative than liberal, but not entirely conservative. It'll be interesting to see what impact Gorsuch and Kavanaugh have on the court. All right, so appointment process. Lowest level of the federal courts are the district courts, and as a result, the appointment process here is the least contentious. When a vacancy occurs in a district court, the president selects a nominee. There's a norm here called senatorial courtesy, which says if a senator who's also a member of the president's party opposes an appointment to a district court in his state, usually the president will withdraw that nominee and nominate someone else. There's no rule that says you have to do this, but typically in the interest of getting along, presidents will honor that. The Senate Judiciary Committee conducts hearings on the nominees, and they will debate their qualifications and their ideology, and ultimately vote on whether or not to confirm them. Hearings are generally routine at the district level. About 90% of all nominees since the 1970s have been approved. Next level up is the Court of Appeals. This one is more powerful, so it is more contentious. More people are paying attention. The formal process is the same as district court judges, but the Senate and outside interest groups pay a lot closer attention here because they have more power, so more people care. As a result of this, the confirmation rate is lower. About a little over a fifth of nominees end up getting rejected here. Holds can also be put on judicial nominees here, which can slow down the process. Historically, those who were qualified were confirmed, but since the 1980s, ideology has taken a greater role as senators have looked at whether or not the judges tend to be liberal or conservative and voted based on their own views. Top level, Supreme Court vacancies are pretty rare, happen every few years. Sometimes, we went 11 years in the 90s until 2000s without a new appointment. Formal process is the same, but it gets a lot of attention, much more contentious. Why? Because the stakes are way higher. A replacement of one judge can change the makeup of the entire court, which is this last one was significant because you replaced Anthony Kennedy, who is really the only true moderate on the Supreme Court, with a conservative in Brett Kavanaugh, which probably is going to move the court to the right. No, although Roberts has shown himself to be a little moderate at times too, so we'll see. If, say, one of the more liberal justices were to be replaced by a conservative, then that would definitely move it to the right. Of course, the opposite of that is also true if, say, Alito or Thomas were to go and be replaced by a liberal, then the court would move back to the left. So this is why the Supreme Court is so important. And I think we may be headed for a crisis here because do you think that after 2020, Trump may still be president, Republicans may still control the Senate, although I'd say the odds of both of those things happening are less than 50%. I would say the odds of a Democrat being president and the Democrats controlling the Senate is also less than 50%. So what happens if you have a president who's of a different party than majority of the Senate? Can they even agree on a appointment? I don't know that they can anymore. If that happens, then we could be headed towards a judicial crisis. Presidents try to choose nominees who are close to them ideologically, hoping to shape the direction of the court. John Roberts was appointed Chief Justice by George W. Bush. I think he was in his mid-40s at the time, so theoretically he could be Chief Justice for 40 years, 50 years even, which means that Bush's influence is going to last long after he's gone. Been a lot more involvement by interest groups, and there's been more rejections. You can see right here. This only goes up to Sotomayor, but you can see interest group support and opposition. There's been a whole lot more of it in recent years. The Senate debates the pros and cons of the nominee. Basically, they consider their qualifications and their ideology, and they vote accordingly. I think Kavanaugh was confirmed. I think it was a 51-49 vote. Virtually every Republican voting for him and virtually every Democrat voting against. I think there may have been a couple exceptions, but by and large, that's how it turned out, because the courts have become much more partisan and ideological in recent years. Now, there have been controversies. One controversy was Robert Bork, who was nominated by Reagan but ultimately rejected. The Senate felt that he was not strong enough on civil rights, and thus he was opposed by civil rights groups and women's rights groups, and ultimately he was voted down. Clarence Thomas was accused of sexual harassment in 1991. Ultimately, he was confirmed, although it was only a 52-48 vote, which was the closest in history up until that point. That's since been broken by Kavanaugh, which was 51-49. Harriet Miers was nominated in 2005. She was criticized as not being perceived as being qualified. She'd never served as a judge before and had been close to the Bush family, so she didn't really have much of a judicial track record. Both Democrats and Republicans didn't really support her, and she ultimately asked that her name be withdrawn. She probably would have been voted down. All right, now let's talk about the state level. Each state has its own judicial system, and most cases are heard here. The reason why? Most crimes are state crimes, not federal crimes. So chances are, if you deal with the judiciary system, it's going to be at the state level, not at the federal level. Cases that involve federal issues can end up in federal court either through a writ of habeas corpus or writ of certiorari. Criminal defendants who have gone through their last appeal at the state level can file a writ of habeas corpus with the U.S. District Court, who can then decide whether or not to hear their case. Any parties that have exhausted their state appeals can also file a request for review, known as a writ of certiorari, directly with the Supreme Court. It's pretty rare that they go directly to the Supreme Court. Usually they start out at the district courts and maybe work their way up to the Supreme Court. If it's something that's time sensitive, like, say, somebody's about to get executed, then writ of certiorari may go to the Supreme Court. But typically the process plays out from the district courts up. So there's the process you can go to. Start out state court, you can appeal to the intermediate court, you can then appeal to the state Supreme Court. From there, you can appeal either directly to the Supreme Court or to, more likely, the U.S. District Court, which may hear your case. From there, you can appeal to the U.S. Court of Appeals, which hears the cases in 3-judge panels. You can also ask after that for an en banc, which means that all the justices on that Court of Appeals hear your case, and you can then appeal from that to the Supreme Court or directly to the Supreme Court. It is a very, very long process, as you can see. It may take over 10 years to get all the way to the top. And most don't. Very few, way less than, only about 1% of appeals the Supreme Court are actually heard. 99% of the time, the lower ruling stands. There are 94 district courts today, 678 judgeships, and trials at district courts are either criminal or civil. We got to talk about this. What's the difference in civil and criminal? A civil case involves monetary damages. It involves broken contracts, things like that. Things that aren't going to result in somebody going to jail. Most federal court cases settle out of court with a agreed upon settlement between the plaintiff and the defendant. So they get together and say, come up with some compromise they can both agree on. Usually the defendant agrees to pay the plaintiff a certain amount of money, which is less than what the plaintiff is asking for, but enough that they can live with it. If it goes to trial, you have these phases. First is the discovery phase, where each side gets access to the information relevant to its suit held by the other side. So each side knows what evidence is going to be presented against them in the trial. Next is the deposition phase. Every witness that each side plans to put on the stand gets brought in before the trial, and the attorneys from the other side question them. So whenever you see a lawyer question a witness and act surprised by the answer, it's totally an act. The lawyer knew what the answer was because they already asked them that question during the deposition phase. If they really are surprised, then it means they're incompetent because they should never ask a question that they don't already know the answer to, and they should know the answer from the deposition phase. Outside interests can file amicus curiae or friend of the court briefs stating their concerns in a case. So if it involves, say, guns, then the NRA and the Brady Center are likely to file briefs arguing, hey, you should rule this way, here's our reasons why. Criminal procedure, these are the ones that can land you in prison, and they begin with an alleged violation of the law, not simply a contract, but with the law. Under the Constitution, criminals in federal court have a right to an indictment by a grand jury. This is not necessarily the case in state crimes. Not all states use the grand jury system. As with civil procedures, though, most of these cases, vast majority, never make it to trial. Over 90% of federal criminal cases are resolved through a plea bargain. What does this mean? Basically, the lawyers, the prosecutor and defense attorneys come together and agree that the defendant will plead guilty to a lesser charge and take a lesser punishment. Most don't actually go to trial. This is probably not how it's supposed to work, but this is how it works these days. All right, Court of Appeals. Above district courts, you have 11 circuits plus the D.C. and federal circuit that hears appeals that deal with patents and customs. Usually they hear them in 3-judge panels. The number of judgeships in each circuit ranges from just 6 in the First Circuit to 29 in the Ninth Circuit. Regardless of how many judgeships the Court of Appeals has, they usually hear appeals from district courts in 3-judge panels. There's the Court of Appeals and district courts. Last but not least, definitely not least, the Supreme Court. 8,000, give or take, losing litigants ask the Supreme Court to hear their case every year. Of those, about 100, only about 100 actually get heard. And the court's decision to hear a case is purely up to the Supreme Court. Typically, they go by the rule of 4. If 4 justices want to hear a case, then they hear the case. If fewer than 4 want to, then they don't. And they have clerks. Supreme Court justices have clerks who weed out sort of the obvious ones the justices aren't going to hear and lower it to a lower number, which then gets sent to the justices themselves. And then those justices, from there, weed those down to a smaller number that they actually will hear. If the Supreme Court agrees to hear your case, you have to submit a brief explaining your argument in the case, and then you get 30 minutes to argue your case before the justices. And frequently during these oral arguments, any justice can interrupt at any point and ask a question. Of course, this can be very stressful because you're trying to present an argument or present a case, and to be interrupted over and over again can completely wreck your train of thought, particularly when you're arguing before the most important court in the United States, maybe in the world. And if you spend 10 minutes answering questions from judges, you don't get to make that up. You get 30 minutes of talk. That includes making your argument and responding to any questions. So your argument better not have any ambiguities, better be pretty clear. And even if it is, they may still ask questions. So after that, each side makes their argument. Within a few days, the justices meet in conference and vote on the merits of the case, and then they decide to assign a justice to write the opinion of the court. The merits of the case is the vote on whether to overturn the lower court's decision. If the Chief Justice is in the majority, he assigns who writes the opinion. If the Chief Justice is in the minority, the Senior Justice who is in the majority appoints someone to write the opinion. And the opinion of the court is the court's justification for its decision and sets the guidelines for how lower courts are to follow them in subsequent cases. And there's 4 types of opinions I want to talk to you about. First is majority opinion. This is the most obvious one. This is the opinion of the court where it lays out the official verdict of the court and explains the reasoning for arriving at it. A concurring opinion is issued by a judge who agrees with the majority result, but disagrees on rationale. So in other words, they agree that the winning party should have won, but they have a different reason for why they should. So if it was, say, Westboro Baptist Church, if 5 justices rule Westboro wins because freedom of speech, and 1 justice thinks, yeah, Westboro should win, but it's freedom of religion, not freedom of speech, they would issue a concurring opinion. Because they agree with the outcome, they just have a different way of getting there. A dissenting opinion is written by the judges who disagree with the majority and criticize the majority opinion and lay out their reasoning for why they disagree. A dissenting opinion obviously has no force of law. It's the majority wins, but a dissenting opinion can be important. If a case is overturned, oftentimes justices will look back at the dissenting opinion in the case they're overturned and use the reasoning laid out in them. So they can have long-term effects sometimes, but they don't have any immediate effects other than just to explain, hey, I disagree with this decision, here's why. A plurality judgment is when a majority of the justices agree on the decision, but not on the rationale for the decision. Going back to the Westboro Baptist decision, let's say you had 3 justices who say Westboro should win because freedom of speech. 3 others say Westboro should win because freedom of religion. And then 3 others who think Westboro should lose. So it's 6-3 in favor of Westboro Baptist Church, but majority disagrees on why they should win. So you would get 2 plurality judgments in this case. All right, the job of the courts is to interpret the law, but sometimes it may appear that they get involved in policy making, what critics call judicial activism. You can try to use what's called a legal approach. This is where the idea that justices base their decisions on legally relevant materials. This is what most justices try to do. Trying to predict how they're going to rule, though, is pretty difficult. I need to update this slide because some of these justices aren't on there anymore. See Anthony Kennedy right there in the middle? He has retired. So, and replaced with Kavanaugh, who's going to be probably somewhere over here. So the court has moved to the right. All right, criminal justice in America. Let's talk about criminal justice a little bit here. I suspect some of you may be criminal justice majors. And if you want to be going to law enforcement, then I applaud you. Obviously, that is a very difficult and dangerous job that doesn't pay a whole lot and doesn't always get the respect it deserves. I want to talk, though, about sort of the broader criminal justice system here. Some people would argue that it's biased against the poor and against minorities. And you think this is the case? Well, let me ask you this. Let's say you have, hypothetical, you have 2 people, both arrested for marijuana possession. Let's say one of these people lives in, let's say, Hardin Valley. Let's say both their parents are doctors, still married. Let's say the other person arrested for marijuana possession, let's say is from, I don't want to be offensive, Harriman. I can say that because I'm from Harriman. Let's say their parents are no longer together, they're divorced, both their parents are meth addicts. Do you think these 2 people are going to be treated the same way by the judicial system? If you think they are, you might be a little too idealistic here. Probably in the first case, the kid is going to get a good lawyer who's going to get him a much better deal. When he shows up in court, he's going to show up wearing a suit and tie, dressed professionally. Both of his parents are going to show up there with him. They're going to look professional. And he's probably, in the grand scheme of his life, this is just going to be a small blip on it. Probably not going to hurt him that much. The other kid is going to get a public defender who, by the way, public defenders are good people mostly. They're doing a difficult job. They're overwhelmed But you cannot, as a lawyer, you cannot provide the same level of representation to someone who you're barely getting paid to represent as you can to someone who's paying you $500 to represent you. If someone's paying you $500 to represent you, you can hire private investigators to investigate every claim the prosecution makes. You can go out and talk to witnesses yourself. If you're a public defender, what you're probably going to do is negotiate a plea bargain. So, answer is probably it is. If you have more money, you can afford better representation, and that makes a huge difference. I meant to update. I forgot to update this statistic. But crime in America. Question. Is the violent crime rate today in the United States higher or lower than it was 30 years ago? If you know Jeopardy. The answer is lower. The violent crime rate today is much lower than it was 30 years ago. Crime in the United States peaked at about the early 90s and has been in steady decline since then. It doesn't feel that way, and most Americans, if you ask them, will think that crime is way up, but it's actually way down. This is good news that most people don't realize. It doesn't feel that way, though, because if you turn on TV, then it's always some horrible crime happening somewhere, or social media, or whatever. But that's just because we see it a lot more than we did in the past. Today, crime rate is much lower than it was. We are safer, actually, than we have been. I think New York City has the lowest crime rate ever recorded, actually. Nationwide, FBI statistics show that the crime rate, I think it ticked up a little in, I want to say, 2015 and 2016, but then went down again in 2017. So, much lower than it has been. There's, of course, the risks are spread unevenly. Of course, this is weird that we're at a time when, like, letting your kid play in the park by themselves will get you reported to CPS, even though, like, 30 years ago, kids did this all the time when it was way more dangerous than now. Of course, the risks are spread unevenly, too. I mean, not saying that not all areas are equal. In other words, every town has a part of town where you would be perfectly safe to go for a walk after dark, and another part of town where it would be much more dangerous. So it's spread unevenly. It also depends on where you are. About 2.3 million people in prison in the United States. Often crowded, very bad places, very tense places. Look at this. I want to show you this chart. Incarceration rate in the United States. About 1980, shot up. Why did it go up so much? The answer is the war on drugs. United States today incarcerates more people, both in real numbers and as a percentage of the population, than any other country in the world except maybe North Korea. So, go us! We're number one, right? Well, probably not something to be happy about. Question. We could do a whole course on why this is, and I don't really want to get too deep into this because it's a challenge just to cover what we have to for this course, and this is sort of this veers over into criminal justice. But there's two scenarios here. Either we're sending too many people to prison for too long, or Americans are just naturally more violent and more prone to criminal activity than citizens of, say, Germany or Canada. Whichever one of those is the case is a problem, right, that we need to think about. All right, law enforcement, police work. As I said, it's very difficult work, dangerous. The pay's not that great, certainly not as much as it should be. A lot of time is spent doing non-crime related tasks, tedious work, rescuing cats, directing traffic around school zones or construction site or in water main breaks. You may spend 8 hours directing traffic, filling out paperwork, pulling over speeders, things like that. So a lot of it is boring, not particularly glamorous. I mean, generally police are supported and have public support and trust, although not always. I mean, as we've seen in recent years, this is certainly not always the case. Of course, there are bad cops too, cops that have sort of, as they say, bad apples that can ruin the whole batch. We also know too that some police forces are better than others. I mean, just is typically. I mean, a police force that has better equipment and pays their officers better money and can, have higher standards for becoming an officer, typically are going to have better police, better departments than ones that struggle even to get anybody to do it. I mean, that's not just true of police, that's going to be true of any occupation. Department of Justice conducts criminal prosecution at the federal level. Oftentimes, the Attorney General will take responsibility for unpopular events like Janet Reno did for Waco, Branch Davidians. Talk about the Federal Bureau of Investigation, the FBI, which is an arm of the Department of Justice. FBI agents are called special agents because they have only special jurisdiction. They can only investigate federal crimes. Local police can invite the FBI in to help, but the FBI can't insert themselves unless they are invited in if it involves state crime. Since 9/11, the focus of the FBI has shifted to terrorism and away from organized crime, which of course is understandable given the 9/11 attacks. We talk about J. Edgar Hoover in the bureaucracy section. You might know the FBI also famously publishes the 10 most wanted list. I think that used to get a lot more attention than it does now. Criminal courts. What you see on TV, is it accurate? The answer is no. Very rarely. Mostly cases are resolved through plea bargaining. Constitution says you have the right to a speedy trial, though if you've ever dealt with the justice system, you may question that. Bail is a big industry around this too. What is bail? Basically, someone guarantees you will show up comes and bails you out of jail. They pay whatever your bail is. In exchange, you agree to show up for court. When you do show up, that person gets their bail money back. If you don't, then they don't. So the idea is that they have a big incentive to make sure you show up because they'll lose their money. Of course, typically, bail is high enough that your average person doesn't have enough money to pay it, so they go through a bondsman, and you pay a bondsman 10% and they bail you out, and you just lose that 10% because that's how the bondsman makes their money. Capital punishment. Death penalty. Controversial. 3,500 people are on death row in the United States. Of course, this is spread out. Some states are more aggressive with it than others. I think Texas may execute more people than all the other states put together. I have to double check on that. They execute the most, I do know that. Blue states don't have the death penalty at all. So, orange states have declared it unconstitutional. Yellow states do have the death penalty, but they have not executed anyone since 1976. Red states have performed execution since 76. Tennessee executes pretty lightly compared to other states that do. We may execute maybe one person per year, something like that. Here's public opinion for the death penalty. You can see it's sort of waxed and waned over the years. In the 60s, it actually, plurality was against it at one point. And then in the 90s, support went all the way up to 80%. I need to update this, but today it's probably more around 60%. So majority supports it, but it's less popular than it once was. How effective is it? Well, depends on your studies. One study, they've been sort of mixed on this. One study found 24 innocent people have been sentenced to death. One of them was executed. There have been innocent people who've been sentenced to death before. They've been exonerated through new evidence, particularly DNA. So, I mean, it's not a perfect system. No system is perfect. Mistakes do get made. So, which is why one reason there's so many appeals for a death row inmate. I mean, you do kind of want to make sure the person is guilty before you execute them. Last but not least, organized crime. Mafia. Who doesn't like to watch The Sopranos or The Godfather or whatever? Of course, organized crime has been in decline, partially due to the Racketeer Influence and Corrupt Organizations Act, or RICO. It may make a comeback, though, as resources post 9/11 have been focused more on terrorism and less on organized crime, it is possible that organized crime will make a comeback. So hopefully not, but it is possible. All right, and that is all we have for today. As always, I will see you back here one last time when we talk about foreign policy. Have a good day. If you have any questions or concerns, let me know. Thank you.